Movies love to show the trial itself, but they don't really show the background and the lead up to the trial. The pretrial is an important step in that background, and it's one of the steps where settlement can be discussed and the matter could potentially be resolved before a trial, so it is very important. In order for you to get a good grasp on what a pretrial is, today I'm going to be going through the what, the why, the when, the who, and the how of pretrial. So let's get into it. First of all, what is a pretrial conference? A pretrial conference is a mandatory proceedings where parties must attend, and each party is given the opportunity to lay out its case and explain itself in front of a judge who will not be the trial judge. This is very important to note. Parties then get together, and it's the avenue for the parties to discuss issues and even maybe put some issues to rest. For example, if liability and damages are on the table at the pretrial, maybe liability can be decided, so that issue is taken off the table for the trial, and it would make the trial shorter. Next up is the why of the pretrial conference. You may be wondering, why don't the parties just go ahead with the trial, forget the pretrial conference, just move ahead? Well, the rules of civil procedure, which are the rules that govern how litigation is conducted in Ontario, Rule 50 and 50.01 state that a pretrial must take place. So that's basically the why of the pretrial. But even from a less rule-based reason, the pretrial is useful in that it brings the parties together, and the parties have the chance to hear each other out before going to the expense and the time that it takes to get to a trial. To emphasize the importance of the pretrial, the rules of civil procedure allow a judge to strike a party's claim or to refuse to grant them an adjournment, or can enter default judgment against the absent party if the party refuses or fails to attend a pretrial conference. It is a very important and mandatory step in the litigation. By way of example, I had a client just recently, I'll call him Mark, just for the sake of this video, not his real name, but he was involved in an accident where he slipped and fell. And the defense was being very hard-nosed about it and was giving him the gears in discovery. They were not very friendly to him. And Mark got very focused on going to trial. He didn't want to attend the pretrial, even though I did tell him that it was mandatory. He just said, let's focus on getting to trial, forget the pretrial. I did explain to him that the pretrial is a very useful step in getting to trial because you can also gather more information about where the other side is coming from and what their case will be. Even though Mark was reluctant, we did go to the pretrial, and while he was sitting there listening to the parties, listening to the judge, he did come to see the value of the pretrial. And in fact, at the pretrial, the judge, who was extremely effective, was a good mediator and was able to sit down with the parties, explain the other party's perspective, explain the judge's perspective in looking at the case. And Mark himself became convinced that he was better off to settle his matter rather than go to trial. This saved Mark a lot of stress and a lot of time and energy, in that the judge was able to assist Mark to see the value in the pretrial and in settling his case sooner than he even thought he would want to. After the pretrial, Mark told me that he was really happy that we had gone, even though, yes, it was a mandatory step, and that we had prepared so thoroughly for it that we were able to resolve in the pretrial, as opposed to months, perhaps even years, sometimes later. He might have been waiting and waiting to get his compensation, but instead we were able to resolve earlier and get him his money sooner. The next aspect of the pretrial you might be wondering about is, when does it take place? As a general rule, after the matter has been set down for trial, within 180 days, the parties will agree on a pretrial date. And if they don't for some reason, then the registrar will schedule a date for them. Moving on to the who participates in the pretrial conference, you might be wondering. And the biggest difference between the pretrial conference and the trial itself is that there will not be witnesses there, so no witnesses are called at the pretrial. The parties that participate are the plaintiff and the defendants, or the plaintiffs if there are multiple, and all of the parties have to have the instructing person there to settle. So if they're not physically there, they have to be available on the phone so that the matter could potentially be resolved that day. If it is a corporation, the person making the decisions in that corporation has to be available in order to settle the matter that day. The other party who will be there will be a judge, as I mentioned, and that judge will not be the same judge who will eventually hear the case if it does proceed to trial. And this is important because you wouldn't want to hear what that judge has to say and then have to go and do a trial in front of that judge knowing basically what they think about the case. It is an important aspect that the judge who hears the pretrial and gives their opinion to the parties is not the same judge who will hear the trial of the action. So that can be good and bad depending. If the judge is favorable to your side, you might be upset that that judge won't be hearing the trial. But if they're not favorable, at least you know, well, even if this judge is not favorable, you might still get a favorable trial decision. But the judge's opinion can be very helpful in giving you insight into what might happen at trial. Lastly, with the how of the pretrial, 30 days before the pretrial, the parties both have to file a certificate of readiness that indicates if they intend to call any expert evidence. The courts have recently really become more interested in having the parties have their experts before the pretrial instead of after scrambling and then having to have a second pretrial because all of the evidence wasn't ready before the first pretrial. So with this, 30 days before the pretrial, the parties have to both indicate that they are ready and if they are calling any expert evidence. 5 days before the pretrial conference, the parties each submit a brief of their argument and their evidence so that the judge can read it ahead of the pretrial conference. The pretrial conference does not take place in a courtroom, although it might take place in the court itself, but in more of a meeting room. Or it can take place virtually. That's the other option. The main objective is to attempt to resolve the issues or some of the issues. It is a very important step, and I hope that this video will have made that clear.